Hello, my name is Tomás Pereira. I'm currently visiting faculty at National Law University Delhi, and I'm a constitutional law scholar working on my JSD, my doctoral dissertation at Yale Law School, on themes related to constitutional amendment and comparative constitutional law. Today we'll be talking about constitutional amendments, their meaning and functions. And the first thing we should bear in mind while talking about constitutional amendments is its intrinsic connection to the very idea of constitutionalisms. This is going to be a theme that is going to guide our conversation today. Notice that I said constitutionalisms, plural, because there are many different ways to define constitutionalism depending on what you have in mind. What is your guiding principle in establishing a typology? So this is also something that's going to appear over and over. So first of all, when we talk about constitutionalisms in regard to its relationship to time, we should think that there are at least three different ways in which the term is used. When we talk about constitutions in the more classical concept, we're talking about it in a descriptive way. We're talking usually simply about the system of government that a state or a legal system has. This is the meaning of constitutions before the modern age, before the revolutions, especially the French and the American Revolution. Because it's only with the French and American Revolution that we can talk about modern constitutionalism. Modern constitutionalism brings the idea of new beginning, of breaking time, of establishing a whole legal system from scratch. And this is what is revolutionary about constitutionalism in this meaning. This is something that is very present in the writing of Hannah Arendt in her book On Revolution, which I recommend, and something that Bruce Ackerman picks up and is very important for his work, especially on his work on We the People. So the connection here between revolution and amendment rules is extremely close. One of the ways people describe the very idea of amendment rules is that it's supposed to domesticate revolution. The idea that big fundamental change in the legal system does not need a armed or any other source of insurrection or disruption of the legal system. It can be done procedurally through a way that is established by the legal system itself. So this is one of the things that amendment rules try to capture. Now, this idea of constitutionalism, it's, let's say, the modern one. It's not the most dominant nowadays. The most dominant nowadays we could talk about it's what some people call new constitutionalism. Has to do with the type of constitutions that were established after the World War II and as democratic waves spread over the world. So you had different waves of democratization or independence movements, and as they happened, new states adopted new constitutions. This new constitutionalism can be described institutionally from three basic characteristics. One, the existence of a Bill of Rights. Second, the idea that there is a constitutional court, or at least a Supreme Court with the power of judicial review. And three, that this Bill of Rights is entrenched. And this is what is very important to us, because entrenchment is directly related to amendment rules. The way in which constitutions are entrenched is by having a procedure that is tougher, stricter, for you to pass a law that changes the constitutional system than what is required to pass normal legislative acts. Bear in mind that the main difference between this wave of new constitutionalism has to do with this higher law degree of constitutions and the possibility of them being enforced by courts. This is something that goes all the way back to the US system and the way their Supreme Court works, at least since the early 19th century, but it was very rare and very exceptional until after the Second World War, and what is remarkable, what is new about this, is that it became the dominant system of organization of government from the 1990s on. The big difference being that until then, parliamentary sovereignty could be described accurately as being the most dominant system around the world. So this has to do with constitutionalism in time. and the relationship between amendment and this idea of entrenchment, which is characteristic of what some authors call new constitutionalism. Right? On this topic, I'll recommend reading Alex Townsend especially. Now, we can also talk about constitutionalisms in terms of how different systems develop constitutionalism itself. Right? One of the ideas that I brought here, because this happened in time, is the idea that constitutionalism can be the product of revolutions, of new beginnings in this formal sense. This is one idea that is very present in constitutions, and amendment rules can capture that in very substantive ways. Another way in which constitutions and amendments relate has to do with constitutions that developed through federalism. They moved from being a federation to being a constitution. This movement from treaty to constitution, as we can call it, is also marked and very much present in amendment rules, right? Because when that movement happens, one of the most important things for the federative units is their importance, is their possibility to influence the center, to influence the union. And so if you're passing your sovereignty or part of your sovereignty power to a centralizing union, you're going to be very sure or going to be very worried about having rules that are going to guarantee that the constitution itself is not going to be substantively amendment in ways that might put an end to the very principle that established this union, being federalism in this case. This can permeate many institutional choices. Like this is one of the bases for having a higher chamber of parliament or a senate that captures representation of federative units. This is one of the reasons why in the appointment of justice to Supreme Court, especially when Supreme Courts have the power of judicial review, and in the power of their impeachment also, this Senate or states would want to have some say in that. And finally, this is very much present in amendment rules themselves. This is present in many countries, but I think a good way to illustrate this is by thinking about the United States system. The United States system is interesting for us because it represents both the revolutionary idea of a constitution that starts from a new beginning, as we said, but also a constitution or a country that is the product of a move from a confederation of sovereign states into a federation, to one union. And if you go to Article 5 of the United States Constitution, which is the article that regulates amendment, this can be seen very clearly. For example, Article 5 establishes that an amendment can be proposed by Congress as long as you have a 2/3 majority vote in both the House of Representatives and the Senate. Notice that the Senate here is also one of the elements bringing federative representation to the amendment process. But then, after being proposed by Congress, a constitutional amendment can be only ratified by 3/4 of the states, which today means 38 out of 50. This is an incredible strong power to states. Means that only 12 out of 50 states, who could represent a lot less than a very small percentage of the whole population of the country, can veto any amendment on the Constitution. I should notice that another way to propose constitutions according to Article 5 is by a constitutional convention called by 2/3 of the state legislatures. Again, states very much present in this procedure, although this was never actually done in the history of the country. Again, this is very present in the limit itself to constitutional amendments. The only pertinent formal limit to constitutional amendments in the United States nowadays is the idea that no state without its consent shall be deprived of its equal suffrage in the Senate. This means that a constitutional amendment that would affect the number of senators each state has would have to have the acceptance of the state itself that is having this representation diminished, which in practice means it will never happen. Again, this is a type of protection that is very much reflective of this relationship between how the Constitution came into being and the amendment rules. In this relationship between federalism and amendment rules, I would notice that, as an observation, that since federalism can be used to protect minorities, this is especially true when a specific minority is concentrated in a federative unit. In that sense, power of the federative unit is also a power to represent that minority. This is particularly common with ethnic minorities or linguistic or religious minorities. But in this case, in this type of case, the constitutional amendment rules is not simply protecting federalism as this abstract idea, but is very much substantively protecting the minorities themselves, right? So, another way to talk about constitutionalisms has to do with not with when they happened or with how a constitution came into being, but has to do with the hierarchy of laws themselves in a system, right? One of these big characteristic elements of constitutions has to do with their nature of being higher law. The idea that constitutional law stands above normal legislation. Now that's the only reason for it being the standard for control of normal legislation. This is why judicial review can actually happen. In this sense, there is a deep relationship between higher law, entrenchment, and amendment rules. The very nature of constitution as higher law has to do with its entrenchment. And its entrenchment is a product of, formally, of the procedure for passing amendment rules being harder or stricter than normal legislation. In this sense, I think it's useful to think of the typology, also by Bruce Ackerman, dividing constitution systems into monism, dualism, and rights foundationalism systems. Each one of these constitutional systems can be thought of as being defined by the very procedure in which amendments happen. For example, monism, what he means by monism is the idea that parliamentary sovereignty rules, that there is no entrenchment, and therefore there is no formal separation between constitutional amendments and normal legislation. The Constitution can be changed or amended by a normal majority vote in Parliament, just like any other law. Another idea is the idea of dualism democracy. Dualist democracy has to do with a system that is democratic first, rights protecting second, but does recognize that there is a higher law nature to constitutional law. This is made formally by having a procedure that is stricter. A third way to think about constitutions is what Bruce Ackerman calls rights foundationalism. Rights foundationalist systems are systems in which the amendment procedure itself is limited, substantively, by some type of principle. So in the comparison between rights foundationalist systems and dualist democracies, what happens is that, as I said, both of them have an idea of constitution as being higher law, as opposed to monism that doesn't think like that. But while dualist democracies are democratic first, rights protecting second, since anything can be changed as long as you follow the procedure, or in other terms, as long as you have the majority to change the constitution, rights foundationalist systems can be thought of or characterized by the idea that they're so rights are so fundamental that even large majorities are forbidden from changing the constitution in their regard. So again, a very deep connection between the whole typology or the whole way in which we even think about constitutional systems and amendment rules. Dualist democracies are characterized by having procedural limits to amendment rules. In a sense, this is very much the manifestation of the very idea of being higher law, and that higher law being expressed by entrenchment, by amendment rules. In this regard, I would notice that some systems, although having only procedural limitations to constitutional amendments, have them in an escalating order. That means that you would have a normal majority that is required for passing legislation, then you're going to have a supermajority that is required for amending the Constitution, and sometimes an even higher majority is required for amending certain aspects of the Constitution. Although this is one way to protect procedurally entrenched constitutional rules, you should always bear in mind that if you do that, any type of entrenchment means in the future, after entrenchment, that a very small percentage of the population has a veto power into any other constitutional change. So the danger with this type of escalating supermajority rules is for a very significant majority, but a very momentous one, being able to change the constitution in a way, and then no other group having the majority to change it again, giving, in fact, a very large power to a very small percentage of the population. This can lead to certain instability. In terms of the third type of constitutionalist systems that we're talking about here, rights foundationalist systems. As I said, they are characterized by the idea of having substantive limits to the amendment power. Because of that, they can become polemic when they are also existing in systems in which you have judicial review of judicial review, because the combination of these two leads to the idea that the judiciary would have the power of judicial review of constitutional amendments themselves. This is not particularly polemic idea when we're talking only about procedures. Now, the idea of judicial review of amendments can happen in systems in which there are no substantive limits to constitutional amendments. It's only that in that case, the only thing that the judiciary will be verifying would be a formal objective element. For example, if the required majority was actually achieved, and therefore if the amendment has passed a procedural test. When you add substantive limits to constitutional amendments, the power or the indeterminacy of what the judicial review court can do is enhanced significantly. This is so with express limits, but there are certain systems in which the idea of implied limits to the constitutional amendment power was developed. In these systems, even though the Constitution mentions no substantive limit to the constitutional amendment power, they were constructed by theory and by the jurisprudence itself. Now this, as you know, is the case of India. So there are also countries in which we have implied limits to the power of amend, or in which this idea exists. Countries in which you have implied limits to the power of amend are countries in which, despite there's no expressed limitation to the power of amendment, they were construed by jurisprudence and by theory, and they are thought as existing. This can happen when the only limit is procedure, bear in mind. They are usually connected with the idea that there is a difference between what the original power that enacted the Constitution can do, as opposed to the constituent power of Parliament, the constitutional amendment power of Parliament. We'll talk a little bit more about that later. In any case, just bear in mind that India is a prime example of this case. But when we're talking about express limits to constitutional amendments, the usual example is Germany. Germany was not the first country to have this type of limits. A lot of older constitutions hadn't, but in older constitutions, there used to be either the type of limitation that you would find used to be republic, form of government, or federation. And because of maybe the non-polemic of these two ideas, or the fact that other institutional elements would be able to guarantee these institutional characteristics without actually needing to use judicial review, they never became particularly polemic. It's only with Germany that this subject matter becomes a prominent matter in comparative constitutional law. And arguably this is because Germany brings this substantive limit in a context of what, as we described in the beginning, of the new constitutionalist wave. This new constitutionalist wave, as we said, is characterized by this constitutional courts and their power of judicial review. So the joining of the power of judicial review by strong constitutional courts and substantive limits to the amending power led to this power actually being exercised. So Germany presents us with examples of constitutional amendments that were considered, that were reviewed by the Constitutional Court. In this mind, having this in mind, let's think a little bit about the procedure or the way it's regulated by the German Constitution. The German Constitution regulates amendments in Article 79, Section 3. It establishes that amendments to the basic law affecting the division of the federation into Länder, which is states, their participation on principle in the legislative process, or the principles laid down in Article 1 and 20 shall be inadmissible. So what it's saying is that Article 1 and 20, besides the other things just said, establish substantive limits to the power to amend. So Article 1.1 is the one that establishes human dignity shall be inviolable, among other things. So this establishes the substantive idea of human dignity as a criteria to be used by the court in their judicial review of constitutional amendments. Besides that, Article 20 establishes that the Federal Republic of Germany is a democratic and social federal state, that all state authorities derive from the people, it shall be exercised by the people through elections and other votes, and through specific legislative, executive, and judicial bodies. And 3, that the legislature shall be bound by the constitutional order, the executive and the judiciary by law and justice. And 4, that all Germans shall have the right to resist any person seeking to abolish this constitutional order if no other remedy is available. So these ideas, the idea of human dignity, the idea of a democracy, the idea of federalism, and even the idea that citizens have the power to resist to their government, oppression by their government, are all enshrined permanently by the limits to amend the German constitution. Other than that, normally constitutions are passed by a simple two-third majority in each one of the chambers. So two-third majority in the Bundestag, which is the equivalent of their lower house, and two-third majority in the Bundesrat, which is their Senate, or the equivalent to their state house, state representative house, would be sufficient. Again, remember what we talked about federalism as being an intrinsic element when thinking about constitutional amendment rules. In the case of Germany, besides the substantive limits that we're talking about, procedurally, the fact that the state, you need a two-third majority by the house that represents the states, is also another way to protect federalism. And on top of that, as you just saw, some of the substantive limits to the power to amend have to do with federalism itself. Again, similarly to what was the situation in the United States example we said, in terms of an older constitution. So having these things in mind, having the idea of how amendment rules connect to the very idea of constitution, thinking of how amendment rules can be representative of how federalism is a central or can be a central element for certain constitutions, and how democracy in a sense, or majority rule in a sense, is also a very important idea for democracy, especially for constitutional democracies, especially constitutional democracies that present popular sovereignty as the principle legitimating the government. We could think a little bit about the rules for constitutional amendment in India. So the first thing to bear in mind is that there are 3 different ways to change things that are established by the Constitution in the Constitution of India. So first of all, there are all these situations in which law that shall not be deemed to be an amendment of this Constitution for the purposes of Article 368. These situations specified by the Constitution itself establish the non-entrenched provisions of the Constitution, in a sense. Establish that there are certain things in the Constitution that can be changed by regular, normal majority. These are situations in which the formal separation between higher law and normal law is not really there. Article 368 is the article that really enshrines the idea of higher law and connects it with stricter rules for amending the Constitution. So Article 368 establishes that an amendment needs to be passed by each house by a majority of a total membership of that house, and by a majority of no less than 2/3 of the members of that house present and voting. Again, pay attention to the connection between the need of a majority, but also the need to respect the representation of the states, right, by requiring a 2/3 majorities in both houses. But on top of that, and this is the third specific procedure for amending a constitution, when the amendment has to do with certain specific parts of the Constitution, Article 54, Article 55, Article 73, Article 162 or Article 241, or Chapter 4 of Part 5, Chapter 5 of Part 6, or Chapter 1 of Part 11, or any of the lists in the 7th schedule, or D, the representation of states in Parliament, or E, provisions of this article. So any of the situations are situations in which you also need approval by, you need that amendment to be ratified by the legislature of no less than 1/2 of the states. So you see another particular strong preoccupation with the representative or the power of the federative units when you're amending the Constitution in matters that regard federalism and also that regard the rule for amending the Constitution itself. Now, having thought of these examples, having talked about this deep connection between amendment rules and how the constitutions came into being, both in terms of how the systems developed sometimes or the importance of federalism itself, and also their connection with a democratic movement, a revolution or some sort of break in the previous legal system, let's think more broadly in the relationship between the procedure by which the Constitution was enacted and amendment rules. So I think it's helpful to ask yourself, is the procedure for amending the Constitution representative of the procedure by which the Constitution itself came into being? In that sense, remember what we talked about constitutional amendments as being a way of domesticating revolutions. If that's the case, what we have is the Constitution establishing that the way to change it is by doing the same thing, by passing through the same type of procedure as it was required to make it in the first time, right? So you have here an idea of almost a reenacting of the fundamental act that generated the Constitution itself. Now, there are two other situations. There are situations in which the procedure for amending the Constitution is harder than the procedure that was required for amending the Constitution itself. Just think of a Constitution that was passed in a procedure that required simple majority in the Constituent Assembly, but amendment requires a 2/3 or 3/4 majorities to pass. In this sense, there can be challenges about the legitimacy of imposing a higher threshold for the next generation to change the Constitution than it was required for the original generation that established the Constitution itself. This is not to say that there's no legitimate arguments for it. One of the most important ones is that sometimes the threshold, the majority required, is higher, but those people are not elected with the special mandate, the specific mandate of enacting a constitution, which could have been the case of the original Constitutional Assembly. So you could imagine that in this case, the higher requirement in terms of a number of votes for passing an amendment is supposed to compensate for the fact that these representatives are being elected in normal legislative elections without the specific mandate that constituents might have had. Again, if the original constituents had that or not is an empirical historical fact. It changes from country to country. Another situation is when the procedure for amending the Constitution is easier than the procedure that was required for amending the Constitution itself. Imagine a Constitution that, besides passing by vote in the Constituent Assembly, also was approved by a referendum, a national referendum, or required approval by all the states. And then you have an amendment procedure rule that does not put such high thresholds in their amendment. When that happens, that can be used to argue that there must be some limits in what constitutional amendments can do. Now, this is a very substantive basis for the discussion regarding immanent limits to the power to amend. Okay? So this substantive idea, the idea or the question that I'm posing here, does the constitutional amendment procedure reenact in a substantive way in terms of the perceived legitimacy by the people, the same type of act that generates the Constitution itself, is in terms of abstract concepts usually discussed as the opposition between constituent power and constituted power, right? This is the idea. This idea presents itself as that constitutional amendments are expressions of constituted power. They are an expression of the constituted order, the order that was constituted by the original power that established the Constitution itself, as opposed to the original constituent power, which would be unlimited by nature. So this is how formally the division between a power to amend that is sometimes quite broad, but not complete, not totally, not capable or not legitimate able to do everything that the original power could do, is expressed. This is an idea that was already very present in France during the French Revolution, and very present in the writings of Abbé Emmanuel Sieyès, in the context of trying to differentiate between the power to establish a constitution and the power to legislate under it. So you can think about how this issue, an issue that is deeply connected to the power to amend, was central to the very idea, to the very genesis of the constitutions themselves, of trying to figure out how they would be able to be established and what kind of limits they would put on the power of the representatives. This is also very present, again, bringing the issue back to India, this is very present in the judgment in Keshavananda Bharati itself. One of the main topics being discussed in the judgment is if there is a difference between constituent power and constituted power. If Parliament, when following the procedures established to amend the Constitution, if they are reenacting the constituent power that generates the Constitution itself, and therefore if it's unlimited in what it can do, or if not. This discussion sometimes is presented in a more formal way, in pertaining the word amendment itself. Some people try to focus on the idea that to amend is different than to abolish, for example, or to simply scratch everything up. Amendment brings in the very word the idea that you are changing something, but that something remains after the amendment was passed. Again, I would invite you to think about how much of this discussion that can sound very formal and very linguistic almost, dictionary-esque, someone could say, how much this actually is a way, a proxy for a larger conversation about what makes a constitutional order legitimate and what gives legitimacy for us to change it. Or in other words, this formal conversation can be hiding a substantive discussion about what is the very basis for legitimacy of the Constitution and what is the authority behind it, and if the amendment procedure is able to capture it in any substantive way. So here I would really bring attention to the connection between constitutional law and constitutional narratives. Constitutional law only makes sense within a narrative. The bare bones legislation cannot be interpreted in any significant way if there is no context to it, right? If you think about, and then if you have that in mind, if you think about how the constitutional text connects with the narrative, the mainstream narrative about the legitimacy of the constitutional order itself, you can ask yourself and think about how the amendment rules relate to it. Do the amendment rules conform and represent in a substantive matter the very ideas that are present in the narratives about what made the constitutional order legitimacy, or do they contradict it? Do the rules for amending the Constitution have some sort of dissonance with the idea of legitimacy? For example, in the case of a constitution that is established and has in its narrative the idea of popular sovereignty, think about how much popular sovereignty is actually present in the amendment procedure. In a constitution that has the idea of federalism or different federative units joining together and making this union into one, only one constitutional order, think about how much the federative representation is present in the amendment rules. Think about the conformity and the contradictions of these ideas, and especially think about it in systems in which both these ideas are present. both these ideas and maybe others are present, and therefore there might be a little bit of each of these ideas in the regulation itself of amendments. So amendment rules in that sense give us insight into the constitutional order, makes us think about the connection between politics, culture, and institutions, right? By looking at this specific institutional mechanism for changing the Constitution, we can think about how it connects with the politics that generated it and with the culture in which that permeates it, right? So I would very much invite you to think about constitutional systems from this perspective, to think about how constitutional amendment rules connect with other ideas present in the constitutional systems. Arguably, among the many ideas that are the many windows into which you can look to understand a constitutional law system, this is one of the most important ones. I would argue that besides this idea, the idea of how justices are selected for the Supreme Court and what kind of competences a constitutional court have in exercising judicial review are the three most fundamental institutional shortcuts or doorways or windows actually for you to think the actual way in which the idea that the constitutional law is higher law manifests itself into specific institutional rules and how much they capture the very deep discussions about what is the source of legitimacy of a constitutional order. Constitutional democracies live within this paradox between the idea of rule of law on one side and the idea of democracy on the other. Constitutional amendments really capture that in substantive ways that make concrete some of these more abstract conversations. So thinking about constitutional law, thinking about the different procedures for constitutional amendments, and thinking moreover into the guiding team that led us in this conversation, the idea that when we talk about constitutionalism, we might be talking about very different phenomena, thinking about very different types of typologies that are concerned about different guiding principles. How much the amendment rules capture these differences in significant ways. Hopefully thinking about this will help you understand other systems when you have to start from scratch to thinking about them, but also would help you to think about your own system and how much your system captures this idea, this principle, and how much the amendment rules represent it for you. Thank you very much. It was a pleasure talking to you about constitutional amendments. Thank you.